am not obsessed with that while answering this question, but public sector undertaking having an apprehension that exclusive choice would result into a kind of not neutral or not impartial situation. Number two, kindly bear, my lord, these examples in mind. I'm not naming the company, but it is a part of a judgment of this honorable court, and I have filed an affidavit. I'm sorry, my lord, just
Yes.
is on something else.
Public sector
Yes.
company.
No, first is a public sector company, my lord, having no level playing field. They choose the arbitrators, particular arbitrators of their choice. And, my lord, there is an apprehension that we usually end up, my lord, not having a level playing field. And I know your lordship knows what is the meaning of that expression. Second example, now in a private domain, there is one company of which I know, and it's a part of the judgment. It's a construction company of a big scale. They enter into contract only to ensure that the contract is eventually terminated midway, and they file arbitration and earn a big award. And I have filed an affidavit on behalf of the company that their main income is out of arbitral awards, not from the business. Now, I am a private company. I am a Larsen and Tobro. I am JSW. I am entering into a contract with that company. And I'm saying that this is going to be my clause in the contract. You take it or leave it. It's a voluntary act. This is, my lord, second example. Please bear these two examples in mind and see how the scheme of the act operates. There is, in every section, every part, there is a party autonomy ingrained. It's not something, my lord, which a party which is insisting for a panel is doing for the first time or doing contrary to law. Lord, please have a look at section 4 now. Develop the
that if you have a
contracts also between A company and B company. There are apprehensions that B company may have a better level playing field than A company in private contracts. But forget everything. Let us see, my lord, what the Act says. And whether,
let's read, we'll read the provisions of the Act and see how you're reading.
yes, my lord. And whether if the Act does not prohibit, alternatively, if the Act permits one party to have a clause regarding there being a panel, which right now, my lord, there is doubt whether it is permissible or not.
So
whether the Act permits. Please come to page section 4. Section 4. Section 4. I'll invite your lordship's attention to only relevant clauses, my lord, just to which assess the court, my lord, in this particular question. Section 4, your lordships have, my lord. I'll read. A party who knows I'm sorry, can I read, my lord, if you lost? A party who knows that A, any provision of this part from which the parties may derogate, or any requirement under this under the arbitration agreement has not been complied with, and yet proceeds with the arbitration without stating his objection to such non-compliance without undue delay, or if a time limit is provided for stating that objection within that period, shall be deemed to have waived his right to so object. My lord, the meaning, as I have understood, is that party, if it is clear that some provision is derogable, but agrees to it, or there is some requirement in the arbitration agreement, but permits it to be waived, if I may use, my lord, my expression, then it is prevented, meaning thereby
There is estoppel principle.
correct, meaning thereby
Estoppel, because
estoppel, you're
right, of estoppel not against a statute will not apply here. No estoppel will apply.
The statute operates as an estoppel. The statute says your conduct operates as an estoppel. We don't have to borrow the.
Now, what do you think are the derogable provisions?
Pardon?
Which are the derogable provisions?
I'll come to that, my lord. Kindly, my lord.
Just bear that in mind. Later on,
I know, my lord. I'll have to answer that, my lord. My learned friend says 34. I have something to say on that, my lord.
And then section 4. Then what is?
Section 4. Lord, this says party autonomy. You can have a provision, and by conduct, you can waive that provision, and thereafter don't object because you are stopped from objecting. That is section 4. Now, please see, my lord, the title of chapter 3, and this is, my lord, relevant. The title of chapter 3, which is section 10 onwards, is composition of arbitral tribunal. Your lordships are
going back to 4. 4 is in two parts. The first part deals with derogable provisions of the Act.
Yes.
The second deals with the arbitration agreement.
Correct.
A requirement of the arbitration agreement.
Yes.
If you don't raise it at the earliest possible opportunity, you are stopped.
I'll just give an example what it means.
It's like the CPC says, objection as to place of suing or territorial jurisdiction. You don't raise a point of territorial jurisdiction at the earliest possible opportunity. You can't raise it later on.
Correct.
If it's otherwise a court of competent jurisdiction, you can't say that the suit was filed in Gurgaon instead of Delhi later.
Another example, my lord, what B means. Lord, your lordships have come across. Your lordships have come across several arbitration clauses. Generally, that arbitration will have to precede the conciliation. That there has to be a conciliation, and if it fails, then arbitration.
That's that clause B, requirement of the arbitration.
Exactly. So that suppose somebody straightway come to the arbitration, participates, then he cannot say that we have missed one.
Conciliation.
That's Malad, the so this is party autonomy. Nothing turns on the question in hand, Malad. Now,
Like the MSME Act says, you must have conciliation and then arbitration.
yes. No, even in several agreements,
Yeah.
there is a provision for conciliation first and then arbitration. Now, chapter 3, composition of the arbitral tribunal. This is the only chapter which provides how arbitral tribunal can be constituted. And as per the definition, sole arbitrator is also a tribunal, multi-member panel is also a tribunal.
Yes.
Now, my lord, 10 is not relevant, my lord, for either of us. Please come to 11. The way, my lord, I would respectfully read section 11. And if my learned friends are right, then we will make one provision at least nugatory. Provision in the chapter of composition of arbitral tribunal. And your lordships would also simultaneously find the party autonomy, a tailor-made, customized agreement is in contemplation of the parliament. Everywhere, my lord, in every section.
Procedure for arbitration.
Yes. Now, 11, my lord. A. 1. A person of any nationality may be an arbitrator unless otherwise agreed by the parties. Here comes party autonomy and the freedom to enter into a contract. This is relevant only to show that parties can agree. The contract is supreme. But second is most important question, important provision.
Procedure for appointing the arbiter.
Subject to subsection 6, the parties are free to agree on a procedure for appointing the arbitrator or arbitrators. Lord, there can be an agreement which says that procedure will be as conventionally followed. I will select my arbitrator, other side will select his arbitrator, and both will request for someone to preside over. That can be one procedure. Another procedure can be you voluntarily enter into a contract which provides for an arbitration agreement which says that the procedure of appointment will be a panel of arbitrators. And you select one from the panel. Correct, my lord? Nothing prevents up to subsection 2 from parties in their act of volition agreeing into an agreement about the procedure for appointment.
Yes.
Now, this interpretation of subsection 2 gets further strengthened by subsection 3. Failing any agreement referred to in subsection 2. So, procedure of your choice, party's choice. If you cannot arrive at or the arbitration agreement is silent, failing any agreement referred to in subsection 2, in an arbitration with 3 arbitrators, each party shall appoint one arbitrator, and the 2 appointed arbitrators shall appoint the 3rd arbitrator who shall act as the presiding arbitrator. So this is the second statutory option. First option is that you choose your method of constituting the tribunal.
So 3 is an exception to 2.
To 2. So other than this conventional method of one electing one selecting one, another selecting second, and they selecting presiding arbitrator is an exception if there is no other customized mode of arbitration tribunal constitution is provided for.
If parties have provided for a procedure for appointment,
Yes,
then that will govern.
that will govern.
So that shows that that procedure for appointment is a derogable provision, isn't it?
Yes.
Subject to, it's a derogable provision. The very fact that he says that it's failing an agreement,
Correct.
show that
That-
once there's an agreement, that agreement prevails.
Yes. Not even one is derogable. That arbitrator can be,
Even a sole arbitrator.
yes, arbitrator can be of any nationality, is also derogable. That unless parties otherwise decide.
The only non-derogable provision.
Yes, it can't be. It can't be. Then, my lord, 3A. The Supreme Court and the High Court shall have the power to designate arbitral institutions from time to time, which have been graded by the Council under Section 43(1) I for the purpose of act. My lord, I'm skipping the proviso. Please come to 4. Subsection 4. So this may not assist your lordships. 3A will have no relevance for this question. Your lordships are on subsection 4, my lord?
Yes, 4.
4. If the appointment procedure in subsection 3 applies, meaning thereby no agreement. Subsection 3 is in absence of customized agreement. Then what? And if there is no such provision, 3 applies, then a party fails to appoint an arbitrator within 30 days from the receipt of a request to do so from the other party, or the 2 appointed arbitrators fail to agree on the third arbitrator within 30 days from the date of their appointment, the appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in case of international commercial arbitration, or by the High Court in case of arbitrations other than international commercial arbitration, as the case may be. So if there is no customized, I'm using that expression, agreement, then 3. If 3 is also not present, then 4. Then kindly come to 5. Failing any agreement referred to in subsection 2. The lordship has that, my lord. So there is no provision for a customized manner of constitution. In an app,
Just for 4 or 5 minutes.
yes, my lord, your lordship may come after 10 minutes.
5 minutes.
Have some
Just
rest.
5 minutes. Just to stretch it. That's all. Yes, Mr. Adam.
Wait, please. Lord, I was on subsection 5.
Yes.
Lord, your lordships would mark one thing, that 4 comes into play when 2 is absent. I hope, my lord, I am
Right, sir.
correct, my lord. 4 comes into play when 2 is absent. 2 is absent when there is no agreement between the parties providing for the procedure.
Yes.
Now, that is first 4 when there is no agreement, then 5, subsection 5. My lord, 5. Yeah,
Yes.
I'm sorry. May I read 5?
Yes.
5. Failing any agreement referred to in subsection 2. So no procedure prescribed. In an arbitration with a sole arbitrator, if the parties fail to agree on the arbitrator within 30 days from the receipt of a request by one party from the other party to so agree, the appointment shall be made on an application of the party in accordance with the provisions contained in subsection 4. The highlight, my lord, which I would respectfully make is that 4 and 5 would come into picture only when there is no procedure under subsection 2. Justice Nasim, my lord, I am able to make 4 and 5 will come only when there is no 2.
Yes.
Now, 6. Where under an appointment procedure agreed upon by the parties, that is under subsection 2, a party fails to act as required under that procedure, or the parties or the 2 appointed arbitrators fail to reach an agreement expected of them under that procedure, or a person, including an institution, fails to perform any function entrusted to him or it under that procedure. My lord, the procedure may stipulate. Just giving a hypothetical example, that in case of a dispute resulting into an arbitration, the arbitral tribunal would be constituted, say, by Delhi Arbitration Center. That can be, my lord, a possible, which is considered, my lord, under 6C. The appointment shall be made on an application of the party by the arbitral institution designated by the Supreme Court in case of international commercial arbitration, or by the High Court in case of arbitrations other than international commercial arbitration, as the case may be, to take necessary measure unless the agreement on the appointment procedure provides other means for securing the appointment. I'm sorry, my lords.
Yes.
Even 6 is derogable. Please see, my lord, 6, last line. If either of these 3 contingencies arise, namely, parties do not appoint, party appointed arbitrators do not appoint a presiding arbitrator, or if an institution is named in the agreement, the institution does not do anything, then the party will approach the High Court or the Supreme Court, but that is subject to last unless the agreement on the appointment procedure provides other means for securing the appointment. So even approaching the Supreme Court or the High Court is also a derogable provision by agreeing to it under an agreement made under 2. My lord, now, my lord, omit 7, it is omitted in 2019. Kindly come to 8. Your lordship has 8.
Yes.
The arbitral institution referred to in subsection 4, 5, and 6. Lord, 6, provided there is no contrary agreement. But let us take that there is an agreement. And either 4 or 5 or 6, the institution which your lordships have designated is approached. Before appointing an arbitrator shall seek a declaration, disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12 and have due regard to. Kindly pause here for a minute. The argument of Mr. Banerjee was that this part is non-derogable. I agree to that. I have a customized agreement under subsection 2. There is a failure and 4, 5 or 6 kicks in. 6 will kick in only, my lord, in case of 2. Correct, my lord? Am I clear? Subsection 6 will kick only when there is an agreement under subsection 2. But then 12 is non-derogable. You cannot appoint a disqualified person who is disqualified under section 12. I'll come to that, my lord. So, my lord, again reading, the arbitral institution referred to in subsection 4, 5, and 6. If we have 2, we are not concerned with 4 and 5. Before appointing an arbitrator, shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12 and have due regard to any qualifications required for the arbitrator by agreement of the parties and the contents of the disclosure and other considerations as are likely to secure the appointment of an independent and impartial arbitrator. But we are not concerned with A and B because their argument was that 8 is non-derogable, to which I have no difficulty. My right under subsection 2, my volition and their volition to enter into a contract with a customized arbitration procedure, customized procedure for appointment of arbitrator will be not bound by section 12. I cannot disqualify anyone. I cannot make my manager an arbitral award. But giving an example, how 8 operates. There cannot be an agreement under subsection 2 which says that my managing director will be the arbitrator because that is prohibited under 12. 12 mandate will apply to my choice and their choice in entering into a contract under subsection 2. Now please come to 12, section 12. Rest will not assist your lordships either way. And my lord, whatever I am skipping, your lordships can take it, is not relevant for either of us. Lord, in such matters, we don't argue, my lord, to win a case or lose a case. We really assist the court. So, 7. Lord, there are some provisions which came in 19, my learned friend Lord points out.
In fact, I was comparing it with your soft copy and then the hard copy because these are the post-19 provisions.
So you relied. The institutional part of it is not. Lord, it does not make any difference to the interpretation. I think he agrees. Are you agreeing or not?
This section is technically not the correct provision.
So the correct provision of 8 is in footnote 2.
Correct. It is the Chief Justice, the High Court or the Supreme Court.
Yes,
Chief Justice or the person or the institution designated by him in appointing an arbitrator shall have due regard to any qualifications required of the arbitrator by the agreement of parties and any other considerations are likely to secure the appointment of an independent and impartial arbitrator.
My lord, the sum and substance of what my learned friend says, and I agree, is instead of institution, please read the Honorable Chief Justice. That's all, my lord. Nothing turns on the interpretation or the issue we are confronted with. Now, please come to, my lord, section 12. I'm sorry, my lord. My lord, the Chief Justice is somewhere, my lord, in some.
Of subsection 8 says other considerations
Yes.
as are likely to secure the appointment of an independent and impartial arbitrator.
When?
Therefore, the court has that duty to ensure that the person you are appointing is independent and impartial.
Yes. Correct, my lord. But that is Lord, even in EPS. That's what I'm saying. Lord, only at the cost of reputation, let me say, Lord, even without this provision, the court has the duty to appoint an impartial and independent arbitrator. Nobody disputes that. But Lord, at the cost of reputation, Lord, please note this. 8 kicks in when 4, 5, 6 is present. And 4, 5, 6, 4 means no agreement under 2. 5 means no agreement under 2. 6 means there is an agreement, but you fail to act. So this does not touch upon the party's autonomy to enter into a contract providing for a specialized mechanism for appointment of arbitrator.
No, but even where the parties have provided for a procedure
Yes,
for the appointment of an arbitrator under 2,
correct.
thereafter, if you look at the provision prior to 2019,
Yes, madam.
it says 6.
Lord,
Where
6.
that 6 prior to the amendment,
Yes, madam.
where under an appointment procedure agreed upon by the parties. So we are now dealing with an agreed procedure.
Yes, but 6
A.
is for that. Madam.
Right. A party fails to act as required under that procedure, or the
Correct.
parties or the 2 arbitrators fail to reach an agreement expected of them,
Correct.
or a person, including an institution, fails to perform, party may request the Supreme Court, or as the case may be the High Court or any person or institution to take the necessary measure, unless you pointed out, unless the agreement on the appointment procedure provides other means other than going to the Supreme Court or the High Court or the institution.
Correct.
All right. Now, when 8 says,
Before that, my lord, kindly pause here for a minute on my request. My lord, 6 definitely would kick in. 6 necessarily presuppose an agreement under 2 and non-compliance of what is stipulated under that agreement.
right.
Correct, my lord. Now kindly come to 8. The arbitral institution referred to in subsection.
Just read 8 from the soft copy, actually.
Yes.
Which is at 111.
Yes, ma'am. Where 8, your lordship.
8. The Supreme Court.
The Supreme Court, or as the case may be the High Court, or the person or institution designated by such court, before appointing an arbitrator, shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1 and 1 of section 12, and have due regard to A, any qualifications required for the arbitrator for the agreement of the parties. So your lordships, your lordship means the Supreme Court or the High Court will also be governed by the agreement under 2.
And B says the contents of the disclosure, and so the disclosure has to be made before you appoint the arbitrator.
Correct.
And other considerations, that's very important, and other considerations as are likely to secure the appointment of an independent and impartial arbitrator.
Correct, my lord.
This seems to suggest that even where parties have agreed to the procedure for the appointment of an arbitrator, but that procedure has not been implemented for a variety of reasons, you move the Supreme Court. Supreme Court is not bound, or the High Court is not bound by that procedure. That's the point.
No, no, my lord.
There are a line of 3 judgments of Justice Lora where under the agreement, there is an obligation to appoint an arbitrator, but one of the parties has not complied, so 11.6 come into the play. It was argued at that stage that now 11.6 has been filed, but when a court appoints, you must appoint according to the arbitration agreement. He has rejected that argument, saying, number one, that freedom no more exists because of non-compliance of you. Now the power and right exclusively rests in the court itself. And we will appoint, and when the court appoints, the procedure contemplated under 8A and B will apply. Those are the line of cases, sir.
In case of non-compliance, we are concerned.
Right, obviously,
Issue arises only on non-compliance.
We are concerned whether two can have a particular procedure or not.
of course, two can have a procedure.
My lord,
But
can
if
we
that
read it again?
procedure has failed and the matter comes to the court, then you are not bound by the rigors of the procedure which have been provided by the
Certainly.
parties.
Well, certainly, but please read it again.
Because when the court appoints, there's an overarching duty of the court to protect independence and impartiality. And therefore, the court is not merely a rubber stamp to say, okay, I'll look at the agreement and I'll appoint the same person or the same people, however lack of independence or impartiality there may be.
No, that's not my argument also. I'm not, my lord, pitching it that high, but please read it again. 8. My lord, what would be your lordship's consideration, the Supreme Court or the High Court's consideration? The Supreme Court, or as the case may be, High Court, or the person or institution designated by such court before appointing an arbitrator shall seek a disclosure in writing from the prospective arbitrator in terms of subsection 1 of section 12 and have due regard to. So this is disqualification disclosure and due regard to. A. Any qualifications required for the arbitrator by the agreement of the parties. Suppose, my lord, agreement of the party says a chief engineer will be appointed. Then your lordships will have a regard to that.
That's because earlier set of cases said that even if court appoints, it must go by the agreement.
Yes.
That
is
got
1940
overruled after
Act.
the amendment and the 2 judgments also.
Yes, 1940 Act. Then, and second, the contents of the disclosure. My lord, disclosure means I come to
By the prospective arbitrator.
12. The disqualification. The contents of the disclosure and other considerations, which is, my lord, a wider, completely wide room, my lord, for the court, my lord. So apart from disclosure, your lordships can likely to will appoint a person who is likely to be independent and impartial. So, my lord, sum and substance is there can be an agreement under 2, complete autonomy. If there is an agreement, but conditions not complied with, you come to 6. While exercising powers under 6, your lordships will examine 8.
But if there is no failure of the procedure, then parties are bound by what is envisaged in that
And
procedure under 2.
And therefore,
That's
2,
absolutely.
yes, brother, 2 does not prohibit parties to agree to a particular procedure, which may include a procedure of selection from the panel.
Invariably, 11 is filed on the ground that I've asked for arbitration, but they are appointing from the panel. So 11.6 is filed on that ground.
No, but they cannot, if they have agreed under.
Cannot, it's your argument.
That's my submission. Yes, yes. The lordships are right. So long as 12 is met. Now kindly come to section 12. Section 12 again is housed in the chapter titled Constitution of the Tribunal, Composition of the Tribunal. Am I with your lordships on section 12?
Yes.
When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any of the circumstances. My lord, he shall. This is non-derogable.
Yes.
So he must disclose, my lord, either approached by the party as per the procedure prescribed under section 11(2) or maybe by the Supreme Court or the High Court. A, such as the existence either direct or indirect of any past or present relationship with or interest in any of the parties or in relation to the subject matter in dispute, whether financial, business, professional, or other kind, which is likely to give rise to justifiable doubts as to his independence and impartiality. Kindly see, my lord, the clauses, because this does not disqualify him. The only, my lord, responsibility is to
Disclose them.
disclose. Then B. And B, my lord, I have a separate submission to make, my lord, for your lordship's kind consideration, which are likely to affect his ability to devote sufficient time to the arbitration, and in particular his ability to complete the entire arbitration within a period of 12 months. This is what a prospective arbitrator is supposed to give. My lord, I'll come to that point. I'm not raising it right now, my lord, but this is a very, very vital point, my lord, which will go to the root of the issue. Then explanation 1. The grounds stated in the 5th schedule my lord, in ICC arbitrations, when an arbitrator is appointed, I'll show, my lord, when I come to that. Sorry. In ICC arbitrations, prospective is approached. My lord, in ICC, my lord, I'm not, my lord, I'm not arguing this right now. At the end, I'll say, but just as a by way of an information, in ICC arbitration, whenever a prospective arbitrator is approached, he is requested, there is a format that give me your calendar of 24 months henceforth. They decide whether he is able to devote sufficient time and whether the arbitrator would be able to complete it within a time period. I'll come to that, my lord, but that a little later. Now, my lord, 2. An arbitrator, subsection 2, from the time of his appointment and throughout the arbitral proceedings, shall, without delay, disclose to the parties in writing any circumstances referred to in subsection 1, unless they have already been informed of by him. Suppose some disqualification, not disqualification, some contingency under 12(1)(a) occurs during the arbitration. So he is supposed to disclose that. So throughout the liability of disclosure continues. Now 3, an arbitrator may be challenged only if A, circumstances exist that give rise to justifiable doubts as to his independence or impartiality. Kindly pause it here pause here for a moment. Lord, this is one of the grounds on which his appointment can be challenged. And if your lordships can now read it with explanation 1, appended to, my lord, immediately after B, subsection B. The grounds stated in fifth schedule shall guide in determining whether circumstances exist which give rise to justifiable doubts as to the independence or impartiality. So this is to be connected with or read with 3A. 5A grounds are generally the guiding principles, but they are not, my lord, the exhaustive list. There can be other, my lord. One of my learned friends said that there is one arbitrator in the panel who always decides in favor of one party. Maybe that can be a ground, my lord, under 3A. That we have a reasonable ground that he is not neutral, he is not impartial, he is not independent. Then B, he does not possess the qualifications agreed to by the parties. Then 4, a party may challenge an arbitrator appointed by him or in whose appointment he has participated only for the reasons of which he becomes aware after the appointment has been made. If he is already aware when the appointment was made, then waive. It is derogable. Then he cannot challenge, a stopper. You cannot challenge. Then 5. 5 is, my lord, non-derogable. Please see, your lordships have seen 12.1, mere disclosure, no consequence. Now 5, notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule shall be ineligible to be appointed as an arbitrator. This is the distinction between 1 and 5.
Yes.
So 1 is mere disclosure, 5 disqualification, he is ineligible. Lord, this will govern 11.2 also. There cannot be an arbitration clause which permits a person falling under 12.5 to become the arbitrator. That is non-derogable.
So Schedule 5 can be derogated from. Parties may say that, well, despite the fact that there may be justifiable doubts as to his impartiality and fairness, I still accept him. So,
I
but
will tell him.
7 schedule is ineligibility.
Yes,
Of
exactly.
exactly.
I understand, but if I agree to 7, I necessarily agree to everything which is in 5
What
akin to 7.
family arbitrator, suppose you
There's a waiver, my lord. Family arbitrator, there's a waiver under 12.5 proviso. You can
12.5
waive, you can waive
Waive
it
afterward.
afterwards. You can
after
waive
the
it.
dispute 7 period.
And that's what the law commission says in paragraph 60, that in family arbitrations, you can waive it. That was one of the examples.
Yes, because it's always advisable that someone related is the arbitrator. No, please see the proviso.
This waiver under 12.5 proviso,
Yes,
it is subsequent to dispute. having
subsequent,
been-
yes.
They can
yes,
do that
yes,
at
yes.
that stage.
It cannot be at 11.2
It
stage.
not be at the stage.
And it has to
beginning.
be,
An express agreement in
and
writing.
it has to be an express agreement. in writing.
Express agreement. Yes.
I know that the arbitrator is my uncle, but we both agree to his arbitration.
Well, therefore, we are not concerned with such a scenario, but absent the proviso and the agreement contemplated, even in family arbitration, 7 would kick in. So, provided that parties may, subsequent to the dispute having arisen between them, waive the applicability of this subsection by an express agreement in writing. So this is not, my lord, this is to be contrasted with other provisions where you can, by conduct, condone ineligibility or disqualification.
Is there any other provision which uses this expression, notwithstanding any prior agreement?
Uh,
Because this is the only provision, I think, which overrides an agreement.
this is, my lord, subject to correction, but other provisions are subject to the agreement to the contrary.
Yes, it's the converse. So
Ah,
therefore,
this is
shows
notwithstanding,
importance.
more rigorous. Otherwise, possibly, my lord, the effect is same.
There's some commentary which I showed yesterday, which said that that list was not drawn up because you could make out wherever it is subject to the contrary, it is not mandatory, and where it is not, it is.
No,
That was
that's
the-
my lord comment. I have something, my lord, I have some reservation. Commentaries, my lord, are ultimately views, but notwithstanding anything to the contrary, or at the end, subject to the contrary agreement, would have the same impact. But notwithstanding anything contrary to the to the agreement means the statute provides prevails. Correct, Manoj? But statute is exempted by the provision by saying that except where parties agree otherwise. So they are converse situations. Yes. Now, my lord, please see.
Section 5 provides for non-derogability in its substantive part, but that is relaxed by the proviso where there is an express agreement between the parties after the dispute has arisen.
Yes. I'm,
Why after the dispute has arisen? Because parties are conscious of what is the nature of the contentious matter.
and the nature of this.
Understanding the contentious matter, they expressly agree in writing.
That my maternal uncle would
That's
arbitrate.
choice, although he may be otherwise cannot be upfront before the dispute has arisen. You must be conscious of the dispute and then express the agreement in writing.
And this is just, my lord,
That's the exception.
academically for interpretation. Some of the provisions say that by conduct, you are deemed to have waived your objection. This is the provision where for 7th schedule, there has to be an express agreement, not merely by conduct or by inaction. By not objecting, you cannot waive. There has to be an express provision.
So
Now-
and the overriding of a prior agreement by subsection 5 is subject to the further exception.
Now, my lord, kindly see 14(1)(b). I'm just, my lord, saying that everything is party autonomy. You can contract whatever what you want to contract. Because instead of a conventional litigation method, you are devising your own method of adjudication. Therefore, the entire act is replete with party autonomy, that you decide. As an example, 14(1)(b), the mandate of an arbitrator shall terminate and he shall be substituted if he withdraws from his office or the parties agree to the termination of his mandate. Parties can even enter into an agreement which says that now henceforth we are in the middle of arbitration, but we terminate your mandate. Everything is party autonomy driven. Then, my lord, please see next chapter, jurisdiction of tribunals. We are not concerned. I'm just, my lord, highlighting the, my lord, heading of the chapter. 16 is competence of arbitral tribunal to rule on its jurisdiction. And 17 is, my lord, interim measures. My lord, we are not supposed to read it. Now, please come to chapter 5. Now, thus far, your lordships were examining sections under the heading composition of the tribunal, with which we are concerned. To whom? By
They will finish by 1 o'clock.
My lord, yeah, Lordships would agree on 2 points. We started little late.
No sooner is.
I started, my lord, further late, my lord, I was answering. And this happens, my lord, when you are on the, to come to bat, my lord, after the first inning. And, my lord, I have not been repetitive or irrelevant, my lord.
Roughly how long?
Not more than, my lord, half an hour.
Try and sort of compress it as much as we can within half an hour.
I'll try.
Yeah, trying to lay down.
Relevance.
Yes, my lord, please come to, my lord, chapter, I'm sorry.
You have been highlighting the principle of party autonomy which runs through the entirety of the act. That's what you're saying.
Yes, Lord. And Lord, I'm also dealing with their submissions, my Lord, which are made in my respectful submission out of context. That's what, my Lord, I'm trying to show by saying that one chapter, composition of tribunal, is over. Now, my Lord, chapter 5, conduct of arbitral proceedings. So the tribunal is constituted, whether it's a sole arbitrator or a multi-member tribunal. Now, how the conduct will take place, please come to 18, my lords. Section 18. Equal treatment of parties, your lordship, say, my lord. My lord, say, my lord.
Yes.
Equal treatment of parties. The parties shall be treated with equality. By whom? By the arbitrator. Because it is in the chapter of conduct of arbitral proceedings. And it next line, my lord, strengthens the interpretation, my lord, I am respectfully giving. The parties shall be treated with equality and each party shall be given full opportunity to present his case. By whom? By the arbitrator. This does not talk of equality in terms of the contract under 11.2. This is before the arbitrator. The tribunal is constituted and now proceedings are going on.
Here, the argument of the other side was that the conduct of the arbitral proceeding would also include the appointment and composition of the arbitral proceeding, the arbitral panel.
Yes, sir. I'm
And that is the,
mindful of
because
that.
I'm sure that you are trying to address that.
Yeah, yes.
Which was argued yesterday.
Yes, sir. Because composition is a separate chapter providing for every step of composition. Conduct has a separate chapter providing for every step in conduct. And unless, my lord, we give that meaning, my lord, how would we reconcile 18? The party shall be treated with equality. By whom? By the arbitrator, and it gets strengthened, and each party shall be given a full opportunity to present his case. By whom? Obviously, during the conduct of arbitral proceedings by the arbitrator. So this equality is not equality of entering into an agreement under 11.2.
This is the manner we also read it.
Yes.
As we read yesterday, because it is immediately followed by 19, which talks about the procedure. And that will be governed by the arbitral. But the argument is that no, even at the stage of appointment, this equality principle should come.
Not treated equally by whom? We are two parties. We can't treat each other equally. We can contract that one will not be equal to the other. It's an act of volition. It's purely in a private domain, private law. When it says giving an opportunity of hearing, my lord, would we give opportunity of hearing to each other? When it is, my lord, under the heading conduct of arbitral proceeding with a mandate that everyone will be heard, means by the tribunal. There cannot be, my lord, with profound respect, any other meaning given to it. To come out of this argument, my lord, the reliance is placed on 21. Now, please come to 21. Unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commences on the date on which a request for that dispute to be referred to arbitration is received by the respondent. The argument is that it is only after this notice, arbitration notice, that the tribunal is constituted. And therefore,
Yes.
18 should be read as
Commencement.
commencement. Lord, why this section 21 is placed in this chapter? Not to ensure that the entire chapter applies to the initial appointment of initial contract, which would determine the method of appointment of arbitrator. Please come to Malot 23. Within a period of time agreed upon by the parties or determined by the arbitral tribunal, the claimant shall state the facts when the claim will be made. There has to be a beginning of time, my lord, when the proceedings continue, proceedings start, that from the date of the notice, within 5 months, you must file your statement of claims because the object of the act is expeditious disposal. 21 is in this chapter only to ensure that parties can use that date as a starting date for filing statement of claim, filing defense, filing documents, etc., etc.
Earlier, on the 40 Act, commencement was declared to be from the time when an arbitrator enters reference.
Correct, my lords.
That they have deliberately changed it to.
Yes, my lord. But my lord, even 21, my lord, please come to 21 again. I'm obliged, my lords. But please come to 21 again, my lord, on my request. Unless otherwise agreed by the parties.
It's a derogable provision.
Yes, so we can say that the date of commencement would be the first meeting of the arbitral tribunal. This is why it is housed in the chapter which provides for conduct of arbitral proceedings. Lord, one more I missed, my lord. I'm obliged to my learned friend.
This procedure will be subject to.
My lord, I'm obliged to my learned friends. My lord, I missed section 19, which furthers my, my lord, respectful interpretation of 18. Please see, my lord, 19. The arbitral tribunal shall not be bound by the Code of Civil Procedure or the Indian Evidence Act. Subject to this part, the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting the proceedings. Failing any agreement referred to in subsection 2, the arbitral tribunal may, subject to this part, conduct the proceedings in the manner it considers appropriate. So 18 is during the conduct of arbitral proceedings. And 19 presupposes that there already a arbitral tribunal in existence. It is constituted under Chapter 2. Now, my lord, please see the first line.
Really would stretched to its logical conclusion mean that the requirement of equality under section 18 would override even an agreed procedure.
Agreed procedure, and my lord, it would make the second part of 18 redundant, that parties will be given full opportunity of hearing. By whom?
Yeah, because
It can't be by each other, that I will hear him and he will hear me.
The relationship is governed by agreement,
11
but the conduct of arbitrator must be equal.
equal.
If it doesn't, then 34 comes in saying that you would not. And it is,
Suppose, my lord, there is an arbitral agreement that they would not have a right of defense except on ABCD grounds. Then 18 kicks in. Then the tribunal is bound to treat both equally and give them full opportunity. Suppose there is an agreement that they will not be heard. Lord, 21 is housed in this chapter 5 because there is a provision for fast track arbitration agreement also. Parties can agree that now this would be the date. Date would be hypothetically the first meeting of the arbitral tribunal, and we agree that it would be over within 3 months. We put it on a fast track. Or this would be the date on which the arbitration has started, and we agree that within 1 month pleadings will be completed. Therefore, to smoothen the conduct of arbitration proceedings, 21 is kept here. Lord, just quickly, 25, just first line, just to show, my lord, party economy autonomy is, my lord, writ large. It runs through the architecture of this act. Default of a party, unless otherwise agreed by the parties, this can be done. Then 26, unless otherwise agreed by the parties, the tribunal may appoint so and so. So parties are free to choose what they are contracting, what is their commercial bargain. Now, Lord, sometimes your lordships do something to achieve the ends of justice in a 226 jurisdiction, which arbitral tribunal also can be conferred with. Please come to section 28, subsection 2. This also is dependent upon the parties agreeing to confer their jurisdiction. The title is Rules Applicable to Substance of Dispute, but relevant, my lord, is 2, subsection 2. The arbitral tribunal shall decide ex equo et bono or amiable compositure only if the parties have expressly authorized it to do so. Otherwise, arbitral tribunal is bound by the terms of the contract. Now, your lordships, my lord, kindly come to 36, 34. May I continue, my lord?
We'll come back after. So we'll ask. Try. Lunch, we will, after the solicitor concludes, in the list which is given to us, we'll first hear counsel appearing for the parties. Then whatever time we are left, we'll give a little time to, the interveners. So we have Mr. Natraj for core, Mr. Arvind Kamath for BMRCL. Then we have Guru in Sundaram Finance, Ms. Madhvi Diwan for Mahindra Mahindra. Then we have Anand Padmanabhan for the petitioner in Equitas. And we have Suman Doval for the respondent in Nilcon. We'll give a little time to each one. And then whatever time remains, we'll ration out between the interveners and wrap it up today in the afternoon. All right, 10 minutes, one counsel on your side. All right. Now 10.
This is not derogable. Time is non-derogable.
I'm appearing for Tata Motor Finance. My application is filed. So, I request your lordships to let's direct my MA to be brought one. That's all.
Don't worry. Yes, Mr.
On section 21, I'll show only two sections, and last section is 36.
So
let-
21 we saw.
Pardon me.
21 we saw, right?
Your lordships have seen. Lord, I have already pointed out 21 why it is there. That you have to have some date to count limitation from. In this context, please see section 43. Subsection 4.
Yes.
May I read? Lord, can we have 43 subsection 4?
Yes.
Well, the title is Limitations. And 4, where the court orders that an arbitral award be set aside, the period between commencement of arbitration and the date of the order of the court shall be excluded in computing the time prescribed by Limitation Act. That is why 21, that there has to be some date from which you count the commencement.
So then what is the commencement?
And 21 also says, unless otherwise agreed by the parties. So the commencement date is also a fluctuating date, can be decided by the parties. And 2 also, subsection 2 of 43. For the purposes of this section and the Limitation Act, an arbitration shall be deemed to have commenced on the date referred to in 21.
Yes.
Similar is the provision of section 9, subsection 2. 9 subsection 2, your lordship has notes. It has nothing to do with constitution of the tribunal, where before commencement of the arbitral proceedings, a court passes an order for any interim measure of protection under subsection 1, the arbitral proceeding shall be commenced within a period of 90 days from the date of such order. For this purpose, my lord, to compute the time from that date, it is, my lord, mentioned. Now, my lord, only section on which my learned friend Mr. Banerjee relied upon, section 34, my lord, please come to 34. S- 34, subsection 2, Roman 5, my lord, that was relied upon by him.
2A5.
2A5, sorry, I'm sorry, I stand corrected. 2A, subsection 5. The argument was, please read, my lord, first. The composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of parties. First, obviously, my lord, if it is not in accordance with the agreement of the parties, the award goes. 34 has this ground, my lord. Second, unless such agreement was in conflict with a provision of this part would mean part 1 applicable to domestic arbitrations. Part 2 is international commercial arbitrations. With a provision of this part from which parties cannot derogate. Lord, I have already pointed out that section 12 is the provision from which you cannot derogate. You cannot exempt disclosure, 5th schedule, and ineligibility in the 7th schedule. And therefore, if arbitral agreement provides for any of these non-derogable part, then 34 will apply, my lord, and the award would be set aside. So this would never, my lord, help my learned friend in canvassing that there is any restriction to section 11(2). And I have been able to show to my, in my respectful submission that everywhere the thread is party autonomy. Now, quickly, my lord, I'll take your lordships to my written submissions. My lord, it is volume 5A. My lord, some of the judgments which I have reproduced, I'll not read. My lord, I respectfully request your lordships that it may be treated as read, but in some cases, I'll give the gist of what it says. My lord, your lordships may come to the bottom of page 35, Centro Trade. Your lordships have this?
Which part is this?
Part 1, part 2, my lord. Part 1, page 35. Arguments, submissions supporting one party having a neutral panel of arbitrators. Lord, ignore the title. Basically, there is no restriction, my lord, in having an agreement agreed to by the parties that the selection would be from one of the panel names. At the foot, my lord, clause 7, 5A, my lord, I'm sorry. Volume 5A.
Part 1 arguments.
Yes, my lord. Page 35.
Highway, page 36.
My lord, Justice,
Got it.
Justice Mishra, my lord,
Yes,
my lord, sir. Lord, I am on clause 7.
Thirty.
Your lordships need not read it. I'll just orally point out what the court held, my lord, in Centro Trade. It is essentially on party autonomy. My lord, this was a typical clause in a contract where, after an arbitral award, that award would be tested by another arbitral tribunal. The court said that it is odd, it is awkward, but nonetheless, we respect the party autonomy, and therefore, Lord, this was. Lord, kindly come to page 36. Lord, this judgment, my lord, in para 8. Lord, only highlighted part may be read, my lord, just for to save time. Therefore, you have this paramount public policy to consider that you are not likely to interfere with this freedom of contract. My lord, this is said in the context of arbitration. So this I am relying upon to show that there can be an agreed clause providing for a panel. Now, Lord, page 37 bottom. Lord, Russell on arbitration. Lord, this para I would like to read, my lord. Further, your lordship gets, my lord, page 37 bottom, clause 14. Russell on arbitration states, further, where the agreement is a commercial agreement and it provides that an arbitral tribunal is to be constituted from a panel wholly appointed by one side, the party not involved in the appointment cannot seek to attack the award on the basis that the procedure would result in an impartial tribunal. The rationale for this is that it is common in commercial contracts that one party has little choice when it comes to the arbitration provisions, and where that party has agreed to the arbitration procedure, they must be taken to have waived any objection. However, the position may be different where non-appointing party is a consumer. My lord, now your lordships may come to 16. My lord, this judgment, this is, my lord, Wilson Taylor Asia Pacific Private Limited. My lord, this is the judgment of Singapore Supreme Court, my lord, authored by Justice Sundaresh Menon.
yeah.
My lord, para 16, page 38.
Yes.
Yes, Lord, 16, Lord, part 4 of present written submissions, my lord. Lord, I'll take your lordships through Page 65, my lord. No, not
They're taking us to the judgment itself.
the judgment, my lord. Yes, my lord. I'm taking a losses to the judgment itself. I'm sorry, my lord. I'm little slow in. I showed you. Lord, it is
Volume 3, page
volume 3, page 4591.
93.
Come again?
Volume 3,
Yes.
page 4591. I'll read only one judgment. No, I'm not reading other judgments. I'll just para 8. Lord, this is Supreme Court of Singapore. Lord, which your lordships would find at page 4589. And His Lordship, the Chief Justice, delivers the judgment at 4591. I'll read only 3 paragraphs. Para 8, my lords, have my lords? Para 8, my Lord Justice Narasimha, Justice Adiwala.
Yes, got it.
The judge held, the impugn order is being discussed, the judge held that the clause constituted an arbitration agreement despite its asymmetrical nature. After an extensive survey of modern Commonwealth authority, the judge decided that a contractual dispute resolution agreement conferring an asymmetrical right, in other words, a right enjoyed by only one party to the agreement but not by the other, to elect whether to arbitrate a future dispute was nevertheless an arbitration agreement. Thus, he dismissed the respondent's argument that the clause was not an arbitration agreement because of its lack of mutuality. The judge also held that the fact that a contractual dispute resolution agreement granted the right to elect whether to arbitrate a future dispute was nevertheless an arbitration agreement. Therefore, the characteristics of optionality in a dispute resolution agreement was not inconsistent with the meaning of the nature of an arbitration agreement. Summing up these principles, he concluded that a contractual dispute resolution agreement which confers an asymmetric right to elect whether to arbitrate a future dispute is properly regarded as so and so. Now, please come to page 4593, para 13. Now, my lord, His Lordship's finding starts. Page para 13.
There were two things. Only one party could seek arbitration. They upheld that. And second, in respect of a future dispute, arbitration was made optional. They said still it's an arbitration agreement.
Yes, well, slightly, my lord,
Slightly different.
no, different, but slightly, my lord, more stringent case than what we have.
It can be a similar.
Even arbitrability was also one-sided. Lord, para 13.
Yeah, arbitrability was one.
Not only the selection of whether to arbitrate was also subject to one party agreeing. Ultimately, I will point out, my lord, wherever any country wanted to prohibit, they have prohibited by legislation, by choice. That will not permit one-sided appointment. Otherwise, my lord, party autonomy is, we can agree that, all right, only one party will decide. Here, my lord, that's not the
There are
case.
instances where statutorily.
Yes, I'm coming to that. Yes, my lord, I'll assist your lordship with that. Lord, 13. In respect of the first of 3 requirements outlined at 11 above, we agreed with the judge and also the appellant that the clause constituted a valid arbitration agreement between the appellant and the respondent. It was immaterial for this purpose that clause A entitled only the respondent but not the appellant to compel its counterparty to arbitrate a dispute, the lack of mutuality characteristics, and made an arbitration of a future dispute entirely optional instead of placing parties under an immediate obligation to arbitrate their disputes, the optionality characteristics. On the weight of modern Commonwealth authority, which the judge considered, neither of these features prevented the court from finding that there was a valid arbitration clause between the parties, and before us, neither party contends otherwise. Now, my lord, coming back to my written submissions. My lord, as a matter of fact, apropos my lord Justice Narasimha's query, my lord, just my lord, हमने कोर्ट जो किया है. Lord, in yesterday, my lord, it was shown in ancestral model law, this restriction was suggested. My lord, I'll just, my lord,
You're right, but it was not specifically imposed because they said that two reasons they gave, three reasons.
few
That the existing provisions are adequate and that it will lead to ambiguity in the law.
correct. Your lordships are right. Now, Lord, kindly come to page 41. My lord, I can skip. They have already argued, my lord, my case, so I'm not. I have put both the sides, my lord, of the coin, but they have, my lord, started and put their part of the arguments. Some of the judgment, my lord, which I relied upon, are also, my lord, relied upon by them. Of course, my lord, I must be thankful to Mr. Banerjee that he said that he is reading from my judgment. That apart. Lord, now, my lord, I am on a page 57 for a very important issue. My learned friend, Mr. Call, read one blog of Jan Paulson. To satisfy your lordships, that unilateral arbitration clause is always to be frowned upon. My lord, your lordships recollects.
Yes.
Now, before I read this, my lord, let me clarify one thing, and this is where, my lord, I think inadvertently the Mr. Call must have missed this. And I'll show, my lord, from his article itself.
Yes.
My lord, in international arbitration law, the word unilateral arbitration has different connotation. Wherever Jan Paulson, my lord, he writes, his concept, my lord, and this is, my lord, very crucial for deciding or for, my lord, understanding the blog which Mr. Call, my lord, heavily relied upon.
Yes.
Lord, Jan Paulson's understanding of unilateral arbitration is, I choose my arbitrator, other party chooses their arbitrator, and both of them choose the presiding arbitrator is unilateral arbitrator because we are choosing our own judges. And therefore, he is the proponent of the theory that arbitral tribunal has to be chosen by a neutral body. So he is not advocating institutional arbitration. He has been a proponent of institutional arbitration, that this system is wrong. That I select my choice of arbitrator, they select their choice of arbitrator, and both of them select one to preside over. That itself he treats as unilateral arbitration. And my lord, just my lord, to show my lord from his blog. But first, let my lord please read my lord page 57. Lord, this is my paraphrasing, but I'll read it from the article also. Lord, please come to, let me read from the article so that my paraphrasing may be objected to because it may have my color. Volume 4, page 3662. In my volume, my lords. My lord, this is the article they have cited. My learned friend missed the first 3 paragraphs.
In the same compilation?
In the same compilation, your lordships may find volume 4.
Volume 4.
Page 3662. There is a tab 26. My lord.
Thanks. This is there.
So this is what Mr. Call relied upon.
Yes.
Let us read, my lord, first three paragraphs. First two also, my lord, would be enough. What is his understanding of unilateral appointment? Then he frowns upon it. What could, your lordship gets, my lord Justice particular.
Yes.
What could be more basic? Arbitrations begin with each side naming an arbitrator. References are occasionally made to fundamental right to name one's arbitrator. But there is no such right. Moreover, if it is existed, it would certainly not be fundamental. The original concept that legitimates arbitration is that an arbitrator in whom both parties have confidence. It is quite unlikely that a party will have confidence in an unknown arbitrator selected by its unloved opponent. My selecting would not be trusted by him, his selecting would not be trusted by me, and therefore it should go to a neutral body for the purpose of constituting the tribunal. He is advocating that. Whether he is pitching it too high, maybe he is right. We do not know, my lord. I can't sit in judgment. But this is his understanding. Now, my lord, please come to page 3663 at the bottom.
No, just read the last paragraph of 3662 also,
Yes.
the common practice.
The common practice of unilateral appointments of co-arbitrators may be said to be popular in the sense of being perceived as a valuable opportunity on which parties insist. This seems clear from the frequency of explicit contractual stipulations to this effect, as well as from similar provisions found in rules devised by arbitral institutions. It may seem surprising to ask whether this is compatible with the very concept of arbitration. Yet, it is a serious question. It touches on a simple but a profound matter. The legitimacy of arbitration rests on the party's confidence in arbitrators. There is every reason to doubt that any party is willing to have its case decided by its opponent's chosen arbitrator.
Let's read next paragraph also.
Yes. The two main purported justifications for the practice of unilateral appointments are hardly convincing. It is said that one, even Homer nods and therefore three heads are better than one, especially when the stakes are high. And two, parties will have greater confidence in the selection of arbitrators selected for their special knowledge or skill. So he is talking about my choosing mine and he choosing his.
The next sentence.
Yet, each of these objectives may just as easily be met when all three arbitrators are chosen jointly or by an appointing authority.
This makes clear that what he's really driving at is that the arbitrator should be selected by a neutral arbitral institution.
Third party, not so.
And unilateral appointment is referred to in the context of unilateral appointment of co-arbitrators, one
Yes.
is by each of them.
One by me, one, and that
Not
is
where one party is appointed.
yes, then entire the meaning, context, and content of the entire blog would change if we understand Jan Paulson's understanding of what he means by the word unilateral appointment. Last para on this page. The only solution which will be reliable in all circumstances is that an arbitrator, no matter the size of the tribunal, should be chosen jointly or selected by a neutral body. This aspect of the process should no longer be misused as a sales argument for arbitration. Confidence enhancement is properly focused on procedural rights, the right to be heard, the opportunity, etc., etc. So, my lord,
Also, where there are unilateral, that arrow also, when specifically deals with unilateral appointment.
yes, as he understood by him.
Not so when there are unilateral appointments. It's obvious that a very different impulse is there. Introducing an understanding element into the of the arbitral tribunal. Disputants tend to be interested in one thing only, a favorable outcome. They exercise their right of unilateral appointment like everything else with that overriding objective in view. The result is speculation about ways and means to shape a favorable tribunal, or at least to avoid a tribunal favorable to the other side, which is logically assumed to be speculating with the same fervor and towards the same end. Forgotten is the search for the arbitrator trusted by both sides. So he talks about unilateral appointments.
Lord, I can do one thing. Lord, Jan Paulson has written a book idea of arbitration. I'll supply that book. This is his understanding of unilateral arbitration. The way we conventionally, my lord, understand, I select my arbitrator, they select their arbitrator, and third person is presiding. That is his understanding.
But in any case, he is canvassing, as we understand, appointment of arbitrator by neutral institutions. That is what he is ultimately
So
canvassing.
we are dealing with ad hoc arbitrations. We are not.
It's a view. It's just, it's a view of
And
very,
it
very
is a
learned
good
person.
view, my lord. It's a new institutional arbitration is always preferable, but that's not the issue before the court right now. We are dealing with ad hoc arbitrations. So therefore, my lord, his view, even if right, will not support the view that a panel is unilateral according to Jan Paulson. Now, my lord, page 58, Gary Bond. My lord, I'll only read one line, my lord, because it is on the same principles, but for page 59. My lord, of course, these are all views. Ultimately, your lordships, in my respectful submission, will have to construe the act. Whether it
Anyhow,
permits or
according to
prohibits.
Party autonomy is one golden thread which runs through the provisions of the Act.
Entire.
If the legislature intends to override party autonomy, that overriding of party autonomy must be expressly set out and then indicated in such terms by the Act, which our Act has not done,
Your
as under 12.5.
Lord, only one para, page 59, third unnumbered para, highlighted part. My lord, para, unnumbered para 3, my lord, this is Gary Bond. I'm told it's considered to be an authority.
Yeah,
Uh, 59, well, I rely on my friend, my lord, who has, my lord, the domain expertise. But page 59, although the issue is often, my lord, I have highlighted it. It's in bold. Although the issue is often highly fact-bound, most courts have upheld provisions in which one party provides a list of potential arbitrators from which the other party must choose an arbitrator. World over, this is global jurisprudence. The only condition is they should be neutral. They should not be my employees or related to me. In other words, they should not have the ineligibility contemplated under Section 12.
All right. What's next, Mr.
Yes.
Secretary?
My lord, limited scrutiny post arbitration, my lord, also, my lord, is one of the factors, because when I choose my arbitrator and they choose their arbitrator, and when there is no level playing field, my lord, in persuading the arbitrators, my lord, when we lose, when we suffer an award, so there is, my lord, your lordship knows, my lord, what happens in 34, and rightly, for good reason. They have a right to decide wrongly also. We can't go into it unless some strict uh, uh, ground mentioned under 34 is made out. So this would disincentivize the arbitration as a mode of dispute resolution. Therefore, my lord, limited scrutiny of 34 may also lead, my lord, to an inference that kind of a neutral body that is not connected with me, what my lord, American court says, intrinsically connected to one party, like my managing director, my consultant. But now I'm not reading. Lord, there is one judgment, and I would strongly, I'm not reading it right now because of lack of time. Lord,
What
there
is saying, the limited ground, so far as the.
limited ground.
So therefore, what's the ground for challenge?
Lord, just to ensure that please approve a contract which I am permitted under 11.2 that from my neutral panel, they will select. They will not select as per their choice. So that 34 virtually is an illusory remedy. Well, that's the submission. Well, there is one. Lord, I'll not read one judgment, but I would strongly recommend that all my lords may read this judgment, my lord, because of lack of time, I'm not reading it. It makes a very interesting read. The Honorable Court, my lord, it's an American judgment, has, my lord, its Board of Education of Berkeley versus W. Harley Miller. Lord, it is a part of our written submissions, my lord, dealing with asymmetrical clauses like this. That one party having a dominant right.
Where did you mention about that?
Yes,
Just
Uh,
the page, that's all.
page 1670.
The written submission,
I'm sorry, 1668. I'm sorry, 1663. It starts.
in the precedence compilation,
Yes, no, our compilation. Our compilation, volume 5. Lord, why?
yeah, 165,
It starts 1663 at 1670.
It's PDF 1665.
I'm grateful.
1670, okay.
I'll read two paragraphs and rest your lordships may read it. It makes an interesting read. It ultimately concludes, my lord, what I am respectfully urging for your lordship's consideration. But the way in which the judgment is written, my lord, makes an interesting reading. The basic problem, my lord, somewhere, lord, right-hand side column, second paragraph from the bottom, my lord, your lordship gets the basic problem.
Okay, 1670,
1670, my lords.
right?
Right-hand side column, second para from bottom. The basic problem, your lordship, my lord Justice Padiwala again. It's very interesting, my lord. I've read it fully, but your lordships may read it at leisure. The basic problem in all arbitration cases could probably best be explained not in terms of legal characterization such as condition precedent, ousting courts of their jurisdiction, or revocability, but rather by a hypothetical case in the tradition of ancient fabulist Aesop. Let us assume for a minute that for some reason all rabbits and all the foxes decide to enter into a contract for mutual security, one provision of which were that the dispute arising out of the contract would be arbitrated by a panel of foxes. Somehow, that shocks our conscience and it doesn't help the rabbits very much either. Now, what happens if we have the same contract with the same arbitration provision, except that disputes will be arbitrated by a panel of wolves? Is there such a community of interest among foxes and wolves that the wolves cannot be impartial? Possibly. Now, what happens if the dispute will be resolved by a panel composed by one squirrel, one elephant, and one wolf? One might conclude that squirrels look like rabbits, wolf look like foxes, and elephant ought to surely be, etc., etc. But eventually, it says that elephant will surely be impartial. Then animal law becomes procedurally very complex. Well, I'm not reading it, but it ultimately reaches a conclusion that this uh, unilateral in the way in which we use it is not illegal. Can go to Lord, please come to, Lord, last 2 points and Lord, I know your lordships are looking at the
No, no,
watch,
you are just on something just.
Okay. Otherwise, I can ensure your lordship.
After a long day of work, we have to have some pleasantries also.
I understand. my lord. But so long as your lordships are looking at the watch, there is no difficulty. I promise
Yeah.
my lords will not be required to look at the calendar.
But here, the example, the rabbits will jump and the fox will trot.
An elephant is treated to be a neutral, obviously, because he doesn't look like either of them. Squirrels resemble rabbits and foxes resemble wolves.
Can I just
Yes, your lordships are right. Well, that's the word. But 65, kindly come to page 65. My Lord Justice Narsimha, my Lord,
Of
this
the
question.
written submissions, no?
Yes, my Lord. My written submission 65, part 5. Asymmetrical arbitration agreements in different jurisdictions. But first, two, my Lord, in global context and present context, my Lord, would be relevant because globally it has different shades, my Lord. Asymmetrical has different meanings, not the way, my Lord, we understand it. My Lord, first, global context. Lord, kindly come to the table directly, my lords. Lord, please come to page 65. Lord, there is a table given. My lords have.
Yes.
Lord, the purpose is to show that whichever country wanted to expressly prohibit one party to provide for a panel, it is so prohibited statutorily. And there is an exception made to the autonomy, party autonomy. Lord, Netherlands, for example, your lordships may kindly, Lord, remember the color scheme, Lord, the legend. Green is permissible and the other color is impermissible. Lord, kindly see the underlined portion. This is, my lord, the statute in Netherlands, Dutch Code of Civil Procedure. Your lordship gets, my lord, that page.
Yes.
If the, my lord, I'll read, my lord. My lords are taking.
Yes.
Page 65, my lord, Netherlands, the statutory prohibition. We don't have, my lord, I'm not repeating. If the arbitration agreement, I'm reading the underlined part, this is the statutory language. If the arbitration agreement gives one of the parties a privileged position with regard to the appointment of the arbitrator or arbitrators, the other party may, despite the method of appointment laid down in that agreement, request the provisional relief judge of the district court within 1 month after commencement of the arbitration to appoint the arbitrator or arbitrators. So the law does not permit, or rather leaves it open for the other side to not agree, even if agreement is providing. Then next is Germany. Similar, my lord, I'll not read it. Same, my lord, it is same. Page 66. Third is Spain. Spain, my lord, page 66.
Yes.
Article 15(2) of Spanish Arbitration Act. Please see 2, subsection 2. The parties are able to freely agree on the procedure for the appointment of the arbitrators, provided that there is no violation of principle of equal treatment. In the absence of any agreement, the following rules shall apply. Lord, my learned friend wants to read 18, which is an equal treatment by the arbitrator, in 11.2. This is how 11.2 could have been if the legislature so intended. I hope, Lord, I am able to make myself clear. 11.2 would have been in this manner if they wanted 18 and 11 to be read together. Then your Lordships may, my Lord, come to page 67, again Spanish, my Lord, subsection 6. Not necessary. Lord, kindly come to 68. Estonia, Lord, section 721(2) of Estonia Code of Civil Procedure, Lord, para 2, subsection 2. If an arbitral agreement gives one of the parties in the formation of an arbitral tribunal an economic or other advantage over the other party, which is materially damaging to the other party, such party may request that the court appoint one arbitrator or several arbitrators differently from the appointment which already took place or from the rules of appointment agreed upon earlier. Clear statutory mandate that you cannot have this. It is derogable. You can agree, other side can agree, or they go to the court. Poland, same. Russia, same. I'm sorry, Manoj, your lordship. May I assist your lordship with any section, Manoj?
The argument was that a similar provision is made in 11.8. 11.8 implicitly recognizes that. That is
11.8, Manoj.
11.8.
But
Other considerations as are likely to secure the appointment of an independent and impartial arbitrator.
yes, Lord, but 11.8 kicks in. So please, Lord, allow me to repeat a little while. Please see 8. The arbitral institution referred to in subsection 4, 5, and 6.
No, the unamended provision is in footnote 2 at the bottom.
Yes, Lord.
The Chief Justice of India shall have due regard to A, the qualification, and B, other considerations as are likely to secure the appointment of an independent and impartial arbitrator.
Yes, Lord.
So therefore, their argument was that when the court exercises the power, you are not hidebound by.
The court is not bound, but that's not, Lord, my argument.
Court is not bound.
But 11. Lord, when a party goes to the court, Lord, when the party would go to the court under 8, in case of the contingency stipulated under 6, please see 6.
Then the court has a wider power.
No, Lord, I'm saying something slightly different. 6, kindly see 6. 8 comes only when we reach the court. We reach the court only if 6 contingency arise. Please see 6, Lord. Where, Lord, the same page, your lordships, where under an appointment procedure agreed upon by the parties. So 11.2. A, party fails to act.
There's a failure of that procedure.
Then only we reach your lordship. So that does not take away 11.2. That confers an additional power
That point was.
on the court. My Lord, page 69 and 70. Lord, I'm on the last point.
Yes.
My lord, last point, page 69 and 70, I have said that Singapore permits such a clause, asymmetrical clause. Britain permits such a clause, asymmetrical clause. But that again is not a decisive factor. The point is, whenever legislature wanted to restrict, it has done so by statute.
Ultimately, we have to construe our statute more than anything.
That's, my lord, the end of the matter. My
Thank
lord,
you.
last point.
Yes.
Last point, my lord. And I would, my lord, really oblige, my lord, if your lordships can consider this, my lord, this is directly linked with this. Please come to section 12. My lord, this is the provision, not a very popular thing to urge, but still, my lord, it is necessary, my lord, at times to urge to ensure that the object is achieved. My lord, 11(1)(b).
B.
Sorry, 12(1)(b). And this is my last point, my lords. Your lordships, yawn is more vocal, my lord, than your lordship's words. But this is my last point, my lord, I can assure your lordships. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances, B, but I'm entering into a little unpopular area, which are likely to affect his ability to devote sufficient time to the arbitration, and in particular, his ability to complete the entire arbitration within a period of 12 months. Lord, this is observed in breach. My learned friend, my lord, says 100% breach. My lord, we are at item, my lord, Mr. Banerjee is also. So now, my lord, I am fortified by.
I'll prove it.
Now, no, why I say
Part 4 are notified. See, the solution to that is to have an arbitration council in place.
I'm
Council in place, it will do all
give me a minute.
all objectives.
Give me a minute more. Why I raise this in this matter? Lord, whenever there is a panel, and I'll give the list of panels, I don't wish to argue, just to illustrate. The panel gives the name of the arbitrator, other details, his qualifications, experience, etc., and the number of arbitrations that particular arbitrator is doing, so that the other party can choose that this arbitrator is doing 9 arbitrations. He may not be able to devote time to my problem, my dispute. So better I will go for some other arbitrator. My lord, I'll give that. Number 2, in ICC, whenever an arbitrator is approached, not only ICC, other institutions also, Lord, arbitrator is called upon to give his 2 years calendar. We have placed that on record. My lord, I'll give the page 1975. Lord, it is the list. I know it's not a.
So making is what we are saying.
Lord, what has happened is,
The spot has being responsible. Because specifically a 43D, we have provided the duties of the council, which will be to formulate timelines, to formulate accreditation, to call for information, how many arbitrations are pending before each. Put it up, all that on the website. Everybody will know how many arbitration each arbitrator holds. What is the timelines? These are the requirements. Now, all of these are ad hoc arbitrations. So even assuming that they are ad hoc, some institutionalization or some kind of a regulation must happen.
Lord,
That was the purpose and object of the council.
I always say,
What your concerns are reflected here under 43D, subsection 2 to
Correct.
K, L.
but my lord, B 12A 1B also says within 1 year, and there is thereafter 6 months extension. But 29A, my lord, I only on the lighter side say, my lord, before arbitrators, that arbitrators are now comparable, and it is on the lighter side, but nothing derogatory, with film stars in 2 ways. We always listen that we couldn't get the dates of this particular stars, therefore we have to appoint. My lord, it's very difficult to get dates. My learned friend would agree. Very difficult. Today's date will go after 3 months, 4 months. And second, film stars operate in 3 shifts. So do arbitrators. Morning shift, afternoon shift, and night shift. It's good, Manoj. There's nothing wrong about it.
Did you say
But
3 shifts or 3 screens?
Manoj, that is Manoj.
Just
I bow down. I bow down, Manoj. I could say only 3 shifts, Manoj.
I was not saying anything.
He was just wondering whether he heard screens or shifts.
Manoj, the lawyers do that, Manoj. That I can vouch for, Manoj. We have been witnesses. Lawyers are hearing from more than one screen.
Unless we shift into this
Neutral
now,
arbitration.
ad hoc arbitration is an unorganized sector.
It is.
It's an unorganized sector. There is no regulation.
Whenever, Malord,
So unless we shift into a
Malord,
situation
in
of
institutional arbitration, this factor is considered. For example, Sarod, Malord, we have a Sarod arbitration. It is considered that this learned arbitrator has more than what can be done within 1.5 years. But 12 months, 6 months extension, but thereafter we survive on 29A. Court keeps on extending. And that's Malord, the hard reality, Malord, the ground reality. And Malord,
Why didn't notify the provision and bring that into existence as an institution?
12(1)B says, Malord, that he has to disclose.
answering that question with the
Why
Chief
is
Justice
the
asking.
government not notifying?
What's the concern?
Can be, Malord. I'll, Malord, consult the government and, Malord, it can be, should be notified.
Notify it immediately.
Certainly.
And you passed an act, right, for the other one? Indian, what is that act called?
That's part of this amended and included in this very chapter.
Malord,
Headed by Justice Hemant Gupta.
Malord, would it still, Malord, I'm posing a question to myself, dilute 12(1)B that you have to complete by 12 months, you have to disclose whether you will be able to complete within 12 months, and extendable period by consent is only 6 months. I leave it at that. Well, so far as, Malord, NBFCs are concerned, the last point.
Mr. Solicitor, what we have done is my learned two judges, brothers, Justice Padial and Justice Mishra, we must have appointed, I think, about 25, 30 young lawyers as arbitrators in this.
That's a better way. That's,
in the
but
smaller
otherwise,
claims
Malord,
of- not necessarily smaller claims, but
no, certainly, Malord, my learned friend, Malord, but Malord, your lordship.
that's the Bombay High Court in winding up matters.
Yes.
Ultimately, it's not about winding up a company, small claims. By consent, we'd appoint arbitrators and not retired judges, we would appoint young lawyers, juniors at the bar who would be
And
appointed.
they are doing it very enthusiastically and within the time. But Malord, I flagged it, Malord. I don't wish to be more unpopular on this argument, Malord. Therefore, I leave it at that. But 12(1)B is a mandate, and there is no consequence of non-compliance with that mandate. Malord, so far as NBFCs are concerned, but there are certain institutions like railways, non-banking financial companies, where they deal with thousands of cases, thousands of arbitrations. No, they will, by the very nature of their function, when I enter into an agreement for taking loan of, say, 2 lakhs or 3 lakhs, I know that there is a different bargaining power. They are taking a greater risk. Something which I cannot borrow from the bank is being borrowed from NBFCs. So I agree to a particular arbitrator. Otherwise, also, Malord, take, for example, a person who has taken a loan of 3 lakhs. Malord, I'm posing a question to myself, do we really expect him to go in search of an arbitrator? He finds an arbitrator who is ready to work as per Schedule 4 fees, etc., and Malord, deal with the NBFC.
Most of the smaller claims proceed ex parte, actually.
Yes, but
Rectification of the lawyers appointed
to
by the
that,
bank.
Malord, there is a solution I am suggesting.
Credit card.
Malord, I have a solution, Malord, which I have placed on record. Malord, there is a solution on record. Malord, there is a, Malord, page Sama, Malord, it is called Sama. One example, there is one example. There is an institution which does online dispute resolution. That's the best thing, Malord, for small, Malord. Sama stands for Samjho Magar Pyar Se. That's Samjhao Magar Pyar Se. That's, forget the name, Malord. They could have chosen a better name. It's called Sama. And Malord, this is at page 1983, volume 5A. Lord, please come to only for a second. Lord, this may perhaps be a game changer. Kindly come to page 2000, my lord, volume 5A.
Let me go on.
Only a minute, my lord. This may be a game changer. Your lordship would
Yes.
really contribute something, my lord, would be able to contribute something. Page 2000. Lord, this is one organization. Volume 5A, page 2000. It is recognized by the High Court, Government of Maharashtra, Bombay, Ministry of Justice, Union of India, etc. But its advisory council is former Chief Justice, Justice Sri Krishna, Justice Kannan, etc., etc. But this is online dispute resolution for small people. And the award comes within 45 days. Not expensive, no major, my lord, delays. I have placed, my lord, on record their entire activity. And this is recognized by many. Many banks have joined this for their small depositors or small problems. The loan agreements of smaller loanees, my lord, have a provision that dispute will be resolved by this. My lord, this, I think, is the solution for smaller depositors. We are not on big sharks, my lord, that's all. Obliged to, Lord. I'm grateful, my lord. I exceeded my time, my lord, but I'm grateful.
Yes, that's right. Now we go to Mr. K. M. Natraj. Yes, Mr. Natraj. Over and above what the solicitors argued, now what is the point that you are making?
In volume 5C, morning I forwarded my short written argument. So both on behalf of the court, that is the petitioner in the main matter which has been referred to the Honorable Court, and also I'm representing IAC, that is Indian International Arbitration Center, which is an intervener. Representing both in the matter.
So what is the substance of it?
Yes.
You can just summarize.
Yes. May I kindly have my short written note, which is at volume 5C.
Yes.
So reflecting on the screen. I'll try to finish as early as possible without repeating any of the points which has been raised by learned solicitor.
Can you tell us?
Yeah,
I mean, just
yes.
formulate what is.
Yes,
not
the
being
first one is
argued.
the party autonomy, which is the basic feature of the
That Mr.
arbitration,
Solicitor
which for a different purpose I'm putting it, for the purpose of analyzing the very reference and the issue, which is the basic feature of the arbitration proceedings.
Your second bullet point is correct. That
Yes,
7.6 arises only if any of the situations provided in A to
Correct.
C are not
Yes.
fulfilled.
Secondly, there is no statutory bar on either of the parties, either independently